Okay, we're going to go ahead and get started. Good afternoon, everyone. I'm Travis Soot, a Senior Tax Manager here at Trout CPA. For today's webinar, we have attorney and partner Dan Desmond from Barley Snyder, who will be talking to you about the Financial Crimes Enforcement Network, FinCEN, Corporate Transparencies Act Beneficial Ownership Reporting Rule. Yes, that is a mouthful. Dan is a business, finance, and municipal attorney experienced in M&A, general business law, corporate governance, and other types of business and finance transactions. He is also a CTA BOI expert and early adopter of understanding the rule and all that is involved for your company to be in compliance. If you have any questions or would like to make a comment, please post your question using the Q&A icon. If we are unable to answer all your questions today, we will follow up with you after the event. At this point, I'm going to go ahead and turn it over to Dan. Thank you, Dan, for being here.
Thank you, Travis, and thank you to Trout for hosting the webinar today. I think there are some clients in the audience of Trout, and I think I can tell you I'm a mutual client of Trout's. So I think they're the best of the best, and I'm proud to be here and talk to you all more about the CTA for short and its beneficial ownership reporting rule and what you need to know. I'd like you to leave here today knowing whether the act applies to you, and if so, what you need to do about it and when you need to do it by. So as Travis mentioned, I'm a partner at Barley Snyder. I've been a partner there about the past 5 years and started in 2011. And I focus mainly on business and M&A, as Travis mentioned, and the incoming chair of the business group starting next year. For about the past year and a half, I've been looking at the CTA very closely and getting ready for that, both in terms of our clients' preparation and how they can respond to it and our own internal preparation, since we are trying to be a one-stop shop for CTA and educate people about it, determine whether they have a filing, and if necessary, help them make the filing or make the filing for them. So I'd like to just start out with a quick disclaimer here. This is just stating that this presentation itself is not legal advice, even though I'm an attorney and speaking on the CTA. We're not establishing an attorney-client relationship, but the great news about this is it allows me to speak freely and give my opinion on matters. So certainly if you have any questions, I'm going to entertain those in the chat. I'll probably wait till the end to answer those, but feel free to fill the chat up and I'll try to address them at the end. We should have some time. So the CTA, in terms of an overview, it was passed in 2021, and it really was born out of, post 9/11, Patriot Act, anti-money laundering, BSA, and counterterrorism efforts. Its goal is to look through shells, so to speak, and determine who the ultimate beneficial owners are of entities. It's very similar to bank customer due diligence, trying to determine who a beneficial owner is of an entity they are lending to. Except with a bank customer due diligence, they're doing that because you're their customer and you want to get a loan out of it. The CTA doesn't really give you anything at the end of the day. It's just a requirement that's been hoisted upon you as a business owner and your entity. So, and they took a very broad approach. In my 13 years of practicing, I can't recall a regulation that had such a broad scope. And in terms of impact, probably second only to Dodd-Frank in terms of the corporate world. And Dodd-Frank was really just targeted at banks and swap participants, and it kind of trickled down to the rest of us. This affects everybody who has an entity. And if you're not exempt, you have an obligation under there. So we're going to get into all of that. The rule also affects the person you're looking at, me here, an attorney and paralegals who form entities. I work a lot with entrepreneurs, startups, seeing companies through the life cycle of their business, buying, selling, succession planning, moving on to other generations. So I form a lot of entities for clients, and I transfer them on to their successors. And that as soon as an entity is formed, there's an obligation to make a CTA filing if it's not exempt. And starting this year, I had to put my name and my paralegal's name on there who formed and directed the forming of the entity. So it affects us as well. As of last year, the estimate was that it would affect approximately 32 million entities. I think we'll find out at the end of the year how many people actually filed, and cost about $22 billion. And that was FinCEN's estimate. So you can see divided by entity, what it's going to cost people to go through with that. The filing itself is free, but getting legal, accounting, and other advice, and just time being money, It's going to cost that much for each entity approximately to make a filing, even though there's no filing fee. The information, once it's made, will be accessible by law enforcement, and if consent is granted, to financial institutions. Other than that, it's not a public record. It's not subject to Freedom of Information Act or right to know law requests. So your information, once you put it on there, it's not accessible by the media or Dan Desmond or anybody else who's snooping around. It's private and only accessible to law enforcement, and if consent is granted by banks. So what we're going to cover today as far as an agenda is, first off, who does the Act apply to? And we're going to get into the definition of a reporting company, which is the entity it applies to, who is a beneficial owner of those entities, and who are company applicants. And then we're going to move into what must be reporting. Assuming you're not exempt and you have a filing obligation, we're going to go through the filing requirements and what you have to report. I'm going to include screenshots from the CTA website, the Beneficial Ownership Information Reporting website, where our firm makes reports on behalf of clients, so you can see exactly what needs to be plugged in there and the fields and everything. We're going to get into when it must be reported. That hinges on when your entity was formed, and the deadline will either be the end of this year, or it'll be 90 days from when your entity was formed this year, or 30 days starting next year. So we'll get into more detail on that. We'll go over how it gets reported, including those screenshots, so you can see what you have to do if you need to make a filing. And then finally, we'll talk about penalties. That's a little bit to be determined, since there haven't been any enforcement actions yet, but we'll go into kind of broad scope what could potentially apply to people or entities who are not complying with the Act. And finally, what we're doing as a law firm, what we've been doing to prepare and implement it, and also some developments. Since the last time I gave this presentation to Trout clients in January, there's been a few lawsuits. There's been a lot of guidance issued through frequently asked questions by FinCEN. And there's been some other developments that I just want to cover briefly, so you can get answers to questions that you might have seen in the news or things like that. So as I mentioned, the first question, what we're going to start with at the top, is who does it apply to? And the first question, and when you're doing a CTA analysis, is, are you a reporting company? And when I say you, I mean your entity. So you have your LLC, your limited partnership, a corporation, any entity that was created by a state filing in the 50 states or a territory, DC, Puerto Rico, could potentially be a reporting company under the Act. And if you were created by a state filing, you're a reporting company unless an exemption applies to you. So it's a very broad scope. Literally everybody from single member LLCs up to multi-member LLCs and other types of entities could have a filing obligation unless they're exempt. So you can see how broad the scope of the Act is. This is just a flow chart showing in graphical form that FinCEN put out, kind of how you can determine whether you're a reporting company. But it basically boils down to, if your entity was created by a state filing and you're not exempt, then you're a reporting company. The second question, if you deemed it, you potentially could be a reporting company, is there an exemption in play? And if you're exempt from the Act, then you're not a reporting company. There are 23 exemptions, as you can see here on the screen. Most of them apply to what I'll call institutional clients, like government banks, credit unions, or public companies, publicly traded companies, certain CPA firms that qualify under Sarbanes-Oxley, and then other types of entities that might apply to an audience today that I'll dive into a little bit more focus in. Entities that are deemed large operating companies, inactive entities, and certain tax exempt entities. I'm going to dive into a little bit more detail on that. But other than those 3 or 4 entities or exemptions that I'll discuss in more detail, most of these do not apply to your average client in the audience today, or my average client. We certainly represent governments and banks and municipal authorities and such, but most of the people we're dealing with are private business owners. So that'll be the focus here. Although certainly, if you have any questions about whether you're exempt and you don't know if you fit into any of these categories, there's a helpful guide that I'll show in a little bit, or you can certainly reach out to me and ask further questions. There's also called the 100% subsidiary exemption, and that does need to be 100% owned. So if you're a exempt entity, all of your 100% entities underneath you that are owned by you are exempt as well, unless you're one of those 4 that you can see on the screen here. The first exemption that I'll dive into a little bit more, and again, this is, the act does not apply to you if you're exempt from it, and you won't have to make a filing, is the large operating company exemption. There's 6 prongs and you have to meet all 6 of those. The big 3 are that you have operations in the United States, you have 21 or more U.S.-based full-time employees, and you have $5 million or more in gross receipts or sales or revenue on the prior year's tax return. So again, U.S. operations, 21 or more full-time employees, and $5 million or more in revenue on last year's tax return. If you're in like a control group and you file with multiple entities, you can consolidate revenue amongst your control group to make them all meet that threshold, but you can't consolidate employees. So if you have an operating company with all your employees, you can't divide half of those into other real estate holding entity or something. The employees have to be in the entity itself in order for it to be exempt. Tax exempt entities is another exemption, and this would be your nonprofits, your political action committees, your charitable trusts. Does not include most homeowners associations unless they're like a 501c. As you can see here, in order to be a tax exempt entity exempt from the CTA, you need to either be a 501c, 527, or 4947. It's a lot of numbers, but that's tax code for you. But respectively, that would be a 501c, a nonprofit entity, charity, political action committee, or charitable trust. So if you're one of those, you do not have a filing obligation. Interestingly, if you are a nonprofit and you've filed for tax exempt status, you know that can sometimes take up to 6 months or so for the IRS to get back to you from the date you actually filed. And it might take your attorney or accountant a little while to prepare that application. If you were formed this year, you only have 90 days to make your CTA filing. So 90 days is less than 6 months, obviously. So if you're formed, if you're formed February 1st, you would have had to make your CTA filing by May 1st or thereabouts. And you might not have, learned that you were tax exempt and gotten your IRS letter until June 1st. So you would have still made a CTA filing, and then you would have updated it. So that's a little quirk, probably a hole in the statute that they probably should have made that gate a little longer for nonprofit entities, but they haven't really thought that much about it. So if you're forming a nonprofit entity, you intend to be tax exempt, but that doesn't mean you're ultimately exempt from the CTA until you get that status. Another exemption that I talk about with clients who own privately held entities is the inactive entity exemption. I really key when I'm talking to privately held clients. I'm really keying on large operating company exemption or inactive entity. Talked about the large operating company one. Inactive entity is something that's truly dormant. It's been sitting in the bullpen. It was created before 2020. It's not engaging in active business, doesn't have money flowing in and out of it of any great amount over $1,000, and it isn't changing ownership. If it's just kind of sitting there static and you meet all of these criteria, you're an inactive entity. You don't have to make any filing. But as soon as you bring that out of the bullpen and put it on the field and start using it, that's no longer going to apply to you. Then you would need to make the filing. So it's either going to stay in the bullpen forever, you're going to dissolve it, or if you start using it, you're going to be non-exempt anymore, and you're going to have to make a filing. So just remember that if you are exempt one day, it doesn't necessarily mean you're always exempt. If you have 25 employees one year and then you dip down to 15, you're no longer a large operating company. You need to make the filing. Same thing that goes with revenue. If you dip below those thresholds, you're no longer a large operating company. You need to make a filing. So it's an exemption that keeps you from the act, but it doesn't mean once and done or once and for all. If you no longer hold that status, then you're not going to be exempt, and you would need to make a filing. Okay, so the 100% subsidiary exemption, the key thing to take away from there is it has to be 100%. When we're talking about joint ventures, sometimes you'll have 2 large operating companies drop a sub down, own it 50-50, call it a JV, do an operating agreement. Each large operating company will be a 50% member, 50% ownership interest member. that entity has to file. They can't rely on 50% parent or 50% parents exemption because it's not 100%. So it's got to be 100%. Doesn't matter if it's 99 and 1. It's got to be 100% controlled. That was not the way I read the act initially. They've since issued this guidance on January 12th and made that clear. Another interpretation that I don't really agree with, but that doesn't matter because the act is what it is and the guidance is what it is. So we got to follow it. So it's got to be 100%, fully 100% owned or controlled by an exempt entity. Other exemptions I mentioned briefly, just list them here again. If you're any of these, a bank, bank holding company, credit union, government, I do some municipal authority work, so that it does include municipal authorities like your water and sewer authorities, publicly traded companies, or certain CPA firms, you are exempt as well. Those are Sarbanes-Oxley registered CPAs. So if you're any of those, the act does not apply to you, but if you're not any of those, then you could potentially be in play and in purview of the statute. So who does that leave left in play? Any small or family business entity that if you don't meet that large operating company exemption and you're operating, you're not in an active entity and you're not a large operating company, you need to file. Real estate holding entities, you're engaging in business, you're holding real estate, but you're not going to have any employees, even if you have the revenue to support it likely. So you're going to be in play. A holding company that a lot of, this act flies in the face of a lot of good legal and tax advice over the years to set up holding companies for organizational and other liability purposes. So say we have, two operating companies and, we put them underneath a holding company structure. The operating companies might meet the large operating company exemption on their own, but holding company cannot rely on subsidiaries exemption. The subsidiary exemption only runs downhill. So if operating company then has a entity underneath it, that entity is 100% owned. It's exempt under subsidiary exemption. But the holding company at the top is not exempt. It can't rely on the kid's exemption, so to speak. So every entity needs to qualify on its own, or it needs to be 100% owned by an exempt entity. So that holding company that's set up there, that would need to make a CTA filing. That would need to tell who its beneficial owners are, even though its subsidiaries don't. Talked about joint ventures already, so it's got to be that 100%. As I mentioned, I do a lot of M&A work. A lot of time, a buyer will form an entity to acquire assets of another entity. The seller in that scenario might be a large operating company, but the buyer in that scenario will just be acquiring assets and won't be able to rely on prior year's tax returns or something because it was just created. So that acquisition vehicle entity might need to make a filing unless it's otherwise exempt. And then finally, if I'm going to talk about trusts in detail, it's still one of the grayer areas of the CTA, but I'll go into that in detail because we have gotten some guidance since the last time I gave this presentation. But the only type of trust that actually needs to make a filing itself is called a statutory trust. And most trusts are not statutory trusts. They're common law trusts. They're created by contract under, trust, a deed of trust or like a trust agreement. And those entities, those trusts, as long as they're just created by a contract, they don't have a CTA filing because they didn't make a filing with the state. Remember, you got to have a filing with the state and not be exempt to be a reporting company. So, but a lot of those trusts will then own business entities. And if they own 25% or more, we need to report who the beneficial owner of that entity is through the trust. So I'll get into how you deal with those as well. Types of entities not in play. One of the most common questions you would get are, what about sole proprietorships, general partnerships, mentioned common law trust or other types of organizations like booster clubs, neighborhood association, just other kind of groups that are created by contract, have some level of corporate formality, but they were not, created by a state filing. If they're not created by a state filing, they can't be a reporting company. So general partnership, it would just be me and Travis going out, selling skis or snowboards or something. Sole proprietorship, that would just be me opening a market stand or something. I'm not filing an LLC to operate those businesses. We're just going into business together or on my own. that is not a reporting company because I didn't file anything with the state. Even if we file a DBA and call ourselves like Desmond's Pizza, it's still Dan Desmond doing business as Desmond's Pizza. That fictitious name in and of itself did not, create an entity like a corporation, LLC, or partnership, limited partnership. So it would not be a reporting company because there's no state filing creating it. So you've determined now you are a reporting company. You have a filing obligation under the CTA. Second question is, who does it apply to in terms of the beneficial owners of the LLC? That's the goal of this statute is to, okay, entity, you're in play of the CTA. We need to know who your owners are. And there are two ways to qualify as a beneficial owner of an LLC. The first is called the ownership prong. That's owning 25% of the entity's interests. That can be directly, indirectly, voting, non-voting. The only type of person who wouldn't qualify as a beneficial owner would be a minor, somebody under the age of 18. You'd report parent or guardian. So if one of my daughters had an ownership interest, and she was 25% owner of an LLC, she would report me or my wife as the owner there. You don't aggregate ownership between spouses. So again, if my wife and I owned 17 and 8% of an LLC, you don't add those together to make us a beneficial owner. You have to qualify under that ownership prong on your own. The trusts, I spend a lot of time advising people on trusts because it gets a little more complicated. And that's because depending on the type of trust, you could have one or more of a trustee, a beneficiary, or a grantor or settler qualify as a beneficial owner. I'll go into a little more detail. It really comes down to what type of trust it is, and most of the trusts I'm looking at are trustees qualify as beneficial owner. I'll explain why, but there's really only a few types of trusts where you'd have like a beneficiary or a settler of that trust, a creator of that trust, listed as a beneficial owner. So again, ownership, you want to focus in on that 25% or more ownership interest of a reporting company. You're a beneficial owner. The other way is a substantial control prong. And like I mentioned at the outset, this is similar to banks' customer due diligence. I believe they do like to know all the 25% owners, and they want to know at least one substantial control person of the entity. The CTA says we want to know all 25%. We want to know all the substantial control persons. So there's no limit on the number of substantial control persons an entity can have. So you want to take away there, even if I don't own 25%, if I exercise substantial control over the entity, I might be a beneficial owner too. Okay, so how do I exercise substantial control? There are a few kind of bright line ways, and that's your senior officer, like a president, CEO, CFO, COO, general counsel, also manager of a manager-managed LLC. If you meet any of those titles, de facto beneficial owner. If you have authority over appointment of the senior officer, majority of the board of directors, you're probably going to be a 25% or more owner in that case. But even if you're not, if you have that authority, maybe you just retained some sort of board appointment powers, then you would be the beneficial owner as well. And then the classic catch-all that statutes like to throw through there. You direct important matters of the reporting company, or you exercise any other form of substantial control. Chances are we're looking at those first two bullets: senior officer, authority over board. That catches almost all these substantial control persons. But of course, if you're not one of those and you're still exercising substantial control somehow, then you would have be a beneficial owner under the Act. It's not limited to one person. So if I had a LLC that was owned 25% by 4 individuals, and then there were 3 managers, I would be, and none of those managers were one of the members, I would be reporting those 4 25% owners as beneficial owners. Then I would also be reporting those 3 managers as substantial control person. And then if I had a 4th person who was named president, and then a 5th who was general counsel or whatever, you see where I'm going. You'd list them all if they exercise substantial control. So no limit on that prong. And if I had an LLC that was owned by 5 people, 20% each, none of them would qualify for an ownership prong, then I'd just be listing those substantial control persons, and there has to be at least one. So you can't say, well, none of us own 25%, so we don't have to report. No, you have to report at least one. So you would be whoever the president of your LLC or other person, or basically you're going to have to appoint one of you to be your CTA beneficial owner, and determine it. And it really would be, I tell people, if I put a contract in front of you, who's going to sign that, or who's making the decisions about the business, and you can usually delve down into that. It is a little bit more fact intensive, if you're not relying on those titles. So that's the second way you can qualify as a beneficial owner under the Act. Just briefly, I want to mention holding companies. I talked about them earlier. In that scenario, I talked about where I have a holding company and two subsidiaries underneath there. Let's pretend that those two subsidiaries were not exempt. So I would file, we're not exempt large operating companies. So I would file for the top line holding company. And then, my subsidiaries underneath there are both owned 100%. So when you report about parent, the FinCEN and CTA already knows who the beneficial owners are of all the entities underneath it. So you don't need to make separate filings you don't need to report separately the beneficial owners for each other entity in there. You still need to make a filing, but you just put the parent company's FinCEN ID, which I'll show you how to do that later. You just put the parent company's FinCEN ID in there as the beneficial owner, because they already know about who the beneficial owners are. It's all about looking who that ultimate owner is at the top line. And one thing I want to talk about, let's say you're in that JV joint venture scenario, and let's say you're an exempt large operating company, and then the other 50% member, or whatever, it doesn't have to be 50%, but let's just say 60-40. I'm the 60% large operating company owner, and my fellow member is a 40%. That entity is not exempt, so I got to report beneficial owners of the 40% owner for this JV entity that we're down at the bottom here. I got to report to the beneficial owners of that non-exempt entity, but my entity is exempt, so I don't need to report who my beneficial owners are on this side, the 60% side, because this entity is exempt. So there's a little box in the web-based form that you check, and you just say exempt entity. I'm not within the purview of the CTA, and I don't need to report my beneficial owners. So you're just, making the representation that you're an exempt entity, and that's self-executing. You just need to know and make that legal conclusion. It is a legal conclusion about whether you're exempt or not. You need to go through the criteria and make that determination on your own or at the advice of counsel. So they have to look at the statute for you. You have to determine whether you meet that. You make that conclusion, there's nothing you need to do. But if you do own that entity, you only own 60%, that entity underneath you still needs to file. So you got to check the box exempt entity, and then your fellow member needs to report who its beneficial owners are on that JV entity at the bottom. Other examples of exempt entities where I'm checking that box for people would be, other than JV, the most common one I'm seeing would be the corporate trustees. People were acting, corporate entities acting as trustees. It's very common in the trust world, in the trust and estates and personal planning world, to have a corporate trustee appointed instead of an individual trustee. And a lot of those corporate trustees are large operating companies. They have enough employees and revenue to qualify as that. So I'm checking the box next to their name as well. So those are kind of the two quirks about holding companies and special rules you want to know about that. So finally, we get to the lawyers. We always leave them for last. The company applicant is the last part 3 of who it applies to, and that would just be who you're looking at now. As I mentioned, I form a lot of entities on behalf of clients. I'm directing people in my office and paralegals and assistants to make filings. So we would be listing Desmond, paralegal or assistant who makes the filing, whether most of it's done online these days, sometimes at the counter in Harrisburg, or Wilmington or wherever we're filing. We can create those entities on behalf of clients, if as of January 1st, 2024, all those entities that are formed on a going forward basis, you have to report who your company applicant is. We can be beneficial owners as well. So let's say you're a single member LLC and you form your LLC yourself. Then you would list yourself as beneficial owner, and you would list yourself as the company applicant. That obviously expressly includes attorneys, paralegals, or others making filing on the client's behalf. It can literally include the person dropping things off at the counter too, even if they don't work for you. If you're using like a filing office, like a CSC or somebody else to do filings for you. Okay, so now we're going to get to the screenshots, as I mentioned earlier, and talk about how it gets reported. There are two ways. There's a fillable PDF form that you can submit online. All the ones I've done have been using this website right here, this BOIE filing.fincen.gov. You go there, and this screen pops up here. And as I mentioned earlier, this is not public information. It's supposed to be secure, so everything you're putting in there is not accessible to the outside world. So I've been using the web-based form, and that's where these screenshots will come from. I think it's been pretty good to use so far. I haven't had too many bugs. Yeah, so I think I woke up like stupidly at like 8 a.m. on New Year's Day and made one of the first. I think I was like number 17 in the country as far as filing. So I don't know what that says about me, other than that I'm dedicated to my clients. So, but hopefully none of you were up at 8 a.m. on New Year's Day making CTA filings. So in terms of what needs to be reported, it's just going to go through what we've talked about prior. All that information I went through, but it's going to really get more into the biographical details. So we talked about, are you a reporting company and who are your beneficial owners? Now we got to tell who that reporting company is and who those beneficial owners and company applicants are. So it'll look, you need to provide your entity name, any doing business as or fictitious names that entity has. So I formed, Dan Desmond LLC, and then I DBA it as fictitious name, it is Desmond's Pizza. Then I got to make I got to list both of those names on there. I got to report the primary business address. That's where it conducts its operations in the U.S. Its jurisdiction of formation, that would be, the Pennsylvania in that scenario, or Delaware, whatever state you're incorporated under. And then your EIN. If you don't have an EIN, you're going to look to one of the other two categories, like TIN or Social Security number, to list there. So that's what you got to report about the reporting company itself. And then we're going to talk about beneficial owners. So in my scenario, I'm going to be putting my name, my date of birth, my residential address. It has to be residential address, home address for beneficial owners. And then I'm going to upload my ID number. I'm going to upload my driver's license or passport. Or I'm going to, which I did this as well on New Year's Day, I'm going to get a FinCEN identifier, and I can report that number in lieu of all that other information, because in order to get a FinCEN identifier, you have to share your name, date of birth, residential address, and upload your driver's license or passport. So one of those two ways you will report your information to FinCEN as a beneficial owner. And again, these are the screenshots directly from the CTA filing website that I linked to earlier. Company applicant info, exactly the same information as a beneficial owner, except you can use a business address instead of a residential address, because your lawyers and paralegals are acting in a business capacity, or whoever's making that filing for you. And you can use a FinCEN ID. So I use mine, whenever we're making reports for entities I've formed, I'm plopping in my FinCEN ID there. And everybody in my firm who's making filings is doing the same thing. So I'm a serial filer. People ask me, do I need to get a FinCEN ID? It might be easier, if you're making like multiple filings, but if you're just making one or even two, might not be worth the hassle. It's really more of a personal decision, but I'm filing all the time. So it would be cumbersome of me or people and my staff who are making filings for clients to, have to upload my driver's license every single time and put in my address and everything. So, and name and date of birth. So it's really a personal decision. Probably depends on the context and how many filings you're going to be making. And then at the end, this is what gives lawyers heartburn. So why a lot of law firms said, we're not touching this, because when you're making a filing on behalf of a client, you need to certify that all the information is accurate and correct. So you hit not agree and you're submitting on behalf of the client, or you're submitting that yourself. So, we made a decision. We thought our clients would expect us to, help them with these filings, and decided to make those filings ourselves. And I'll get to, because of that, and I'll get to some information we request of clients, and, in order to protect us and to get assurances that everything in there is accurate. So, but that's, where you're certifying that everything in there is accurate. And so if you obviously are lying or concealing or committing fraud about something in your filing, and you submit it, you might be in violation of the act and, committing a crime. So it can be serious. And obviously, you want to make sure everything in there is accurate if you're doing it on behalf of somebody else. So just pay attention to that and understand the importance of hitting I agree and submitting. When you make a successful filing, this is what you get. This is one we did last week, it looks like. So you get you have to download this. So it doesn't just pop up, but you can download a transcript when you make a filing. I recommend everybody do that. This is the only proof you'll get that the filing was actually made. I think as of last week, they started sending email confirmations, but they don't send the actual transcript. And this is the paper filing that is proof that you made that filing. It also is your reference point, as I'll get to in a little bit, about what did I report 5 years ago, when Dan told me I need to make that filing. Who did I put on there? Has my address changed? Do I need to make any updates? Well, you might, and you're going to want to go back to this, just like an old tax return or something, and see what was on there, so you know what you reported and if you need to update any inaccuracies or changes. So as I mentioned earlier, when I'm making that representation on behalf of clients that everything in that report is accurate, I'm getting them to verify that everything in there is accurate and telling me that. So I have a basis to make that representation to FinCEN, the federal government. So I created this questionnaire and certificate that is kind of like a cheat sheet. Number one, to determine if the CTA applies to you. If it does, and that's, are you a reporting company, like the analysis we went through at the start of this? And if you are, then who are your beneficial owners? And so this is what I put in front of clients when they're asking us to make filings on behalf of us. And that allows them to kind of, I go through this with them on the phone, but it kind of reinforces to them, why I'm asking for this information, and making sure that they're not exempt. Most people know when they're exempt, and but I still got to go through it with them and talk about those employee and revenue. And sometimes there can be a little bit more complicated situations. So it's good. I always like to have a phone call with clients to go over that and answer their questions. And then we have them fill out the certificate. We put all the information in that needs to be reported, and then we ask them to sign off on that everything in there is accurate, correct, and that they'll let us know if anything in there changes. So we have them sign that. We also include the company applicant information. And if it was formed before January 1st of this year, so 2023 or before, I just cross this out. I don't need that information. If it's formed afterwards, I need to know who the attorney and paralegal who created the entity, or other individuals who created the entity, are on that, and that needs to be reported as well. So if you are using like a filing service to form entities for you, or you're using somebody else, I would make sure you get their FinCEN ID number, because you're going to want to put that on here for the person that made the filing for you. And you don't want to be in a situation on day 89 or day 29 of your filing obligation, emailing filing service provider, I need that FinCEN ID number to make my report on time. So make sure you get that if you're using somebody else to make a filing for you. If we're making these filings for you, we have all that in-house. So we just put our numbers on there. So you heard me mention the day 29 and day 89. This is we're going to cover now when the filing must be reported, and when all these CTA filings have to be reported. So you've gone through the analysis of, am I a reporting company? If so, who are my beneficial owners? And now I need to know when do I need to report it by? So the answer to that depends on when your entity was formed. If you were formed 2023 or before, you have all of this year, in fact, until January 1st, 2025, excuse me, in order to make your filing. If you were formed in 2024, you have 90 days from the date of filing. It was originally 30 days. They decided to give an extra 60 days because publicity hasn't been all that great about this act, despite Barley and Trout's best efforts. So, but nationally, a lot of people still probably haven't even heard about it. So, and starting next year, January 1st, 2025. If you're formed on or after that date, you have 30 days. So it's getting smaller, and it's you're going to really need to make that filing as soon as you form the entity. When we're filing entities on behalf and creating entities on behalf of clients, we're just making the filing right away for them. It's just kind of part of our package, our entity formation packages. We're going to do the CTA filing for you because, again, we don't want you coming to us on day 29 or day 209 and saying, oh, well, what's this Corporate Transparency Act thing? We told you about that, but we're just going to do it for you right away, so we don't have to worry about that. Okay, so you made your filing. Everything on there is accurate and complete as of the date you make your filing. And then next year, you change the address, your office moves. Mom or dad transfers their shares down to kids or grandkids. Your beneficial owners might change. Anything on your filing, that transcript that changes, if there's something different on there, if there's something new, you need to make an update or correction to that report within 30 days of the occurrence of the change. So succession planning effective, August 1st, 2024. Let's say we made our filing back in February, but then we did some succession planning. Dad transferred all his shares to kids, and mom went from a 40% owner to a 20% owner. Well, guess what? Dad and mom are no longer beneficial owners, and now we have some new beneficial owners. So we got to file an update by August 31st, 30 days of the occurrence of the change. So that's why you need to inform or be aware of, if you're making these changes in ownership, or even just changing something like your name or your address or your entity, then you need to update that. I told you earlier, you're going to have your residential address on there. Yes, if you move houses, you need to update your CTA filing, and because your residential address changed. It's very cumbersome. So just be aware when you make that filing, keep a copy of it, and if anything on there changes, especially if it's you who's causing that change, let your company know, or who's ever making the filings for you, to update that information. Let's say we put something on there that wasn't right. We got some bad information, or maybe you just put in the wrong name. You forgot a DBA. You put that you lived on King Street in Alabama instead of Pennsylvania, or something like that. You need to update that filing and make the correction, or maybe I screwed up and it's my fault, and I'll own that. But we got to make that update and correction. So that's why we always send a copy of the filing to clients, and we say, just take a second, third look at this, make sure everything in there is accurate, number one, and make sure everything, if anything changes, to let us know. So you have 30 days of the awareness of the inaccuracy. There is a 90-day safe harbor where they say if you do it, it's 30 days, the statute requirement, but if you do it within 90 days, then there's going to be no penalty. So really be aware of that right from the get-go. Make sure you let anybody know if anything in there changes. So if you willfully violate the act, and again, you're probably intentionally misleading, leaving information off, maybe you're concealing a beneficial owner, you're lying about something on that filing, and you willfully did that, then you could be facing civil penalties, $500 a day, criminal fines, and imprisonment up to 2 years. And you're also lying to the federal government, so that's probably another violation of a statute. So if you find yourself in that situation, make that update as soon as possible, and realize that the statute does have teeth in it. The stated goal, as I mentioned at the beginning, is to fight drug trade, terrorism financing, and money laundering. So they're trying to go after the Pablo Escobars and moguls, oligarchs or whatever of the world, who are hiding money, or laundering money, or doing bad things in using U.S. entities to do them. then the federal government's going to want to know who those owners are. And if you're committing a fraud to conceal those persons, then you could have an issue. You could, wind up in jail or something like that. So, Act does have some teeth behind it. Still in the first year of its existence, haven't seen any enforcement actions yet. We don't know exactly how the government's going to go after people. But just remember, obviously, Al Capone was busted for tax evasion, so it wasn't for being the mafia kingpin of Chicago. So they got him on tax evasion. So, this could be even a foot fault and part of a larger criminal conspiracy, but this could be how they get people. I don't know. Or they could, just be slapping people on the wrist and saying, you need to make your filing as soon as possible and make good on it, or else you could face fines. We don't know what it's going to look like, and we'll be putting out alerts and stuff as soon as we learn more about that. But this is what they can do under it. Reporting companies, beneficial owners, and filers all may be held liable. So that's LLC, that's you, beneficial owner, and that's me, the filer. If I make it for you, all three of us could be in the same boat, as far as being held liable. And if you're a senior officer of that LLC or whoever reporting company, you could be individual responsible as well. So obviously serious and something you should take seriously. Again, takeaway as far as who they're gonna go after is a willful violation. So I don't think we're talking foot faults or silly mistakes, typos, things like that. But I guess it'll be know it when they see it. As far as federal government and law enforcement, they'll know it when they see it and determine whether you're willfully violating. Then they'll charge you, and you gotta prove that it wasn't a willful violation. So the burden's on you then. So what have we been doing the past year and a half? We formed a task force at the firm to get ready for this and prepare for it. We've been doing client alerts. This is probably the 12th, 13th, 14th, 15th webinar I've given. I'm giving another one next month at a local bar association. So I've been doing a lot of these webinars. There's one on our website. If you want to check that out, or you missed part of this or something, I think Trout could probably give you a copy too if you ask for it. So we've been doing a lot of emails and letters to clients, client alerts as developments come out, and trying to keep people within our firm apprised of developments in the law and giving updates like this webinar here. We also created a website, that links to information on who at Barley can help you, what's going on with the act, what are the latest client alerts, and helps you determine are you a reporting company and things like that, and all the resources and a lot of the information that I provided here today. There are resources there to get if you'd like to visit the website. We've also been doing, as I mentioned, that questionnaire and certificate for clients who are forming new entities or asking us to file reports. We've come up with some form operating agreement language to, put into and I'll show you in a minute here, to put into an operating agreement or shareholders agreement, really putting the onus on the member or the shareholder or the partner or what have you to inform the company if any information in the CTA filing changes, so that company isn't responsible for a change that they have no idea happened. The members should be updating the company or the senior officer about whether something in there changed. We haven't been going back and touching every operating agreement we ever created or telling our clients to update it, but it is a best practice to have that language in there, and it does kind of insulate the company a little bit to have that language in there so that they can be protected against a member not telling them something changed. Anytime every entity I've formed since 2011 when I started practicing, I have a checklist, and that's how I've sent out emails to a lot of people I haven't talked to in 10 years, but I formed an LLC for them at one point. And I said, hey, you probably have an obligation here. Set up a call and we'll chat about it. We have for all entities or forming going forward, we're creating a database so that we have a list of all those entities so that we know who to contact if they have a filing obligation, things about like CTA, and also Pennsylvania annual reporting, which is coming down the pike in about 3.5 months, starting January 1st, 2025. All Pennsylvania entities will need to make annual filings. There's no exemptions for that. So I shouldn't say that. There are a few exemptions, but not as many as the CTA. So stay tuned on that. I mentioned earlier what that form operating agreement looks like. So this is just basically stating, the reporting persons will update the company if anything in their CTA information should change. Then they'll let the company know about that. So happy to talk to you about that if you think you might want that in one of your agreements. I think this is probably where my last presentation ended. I want to leave time for questions here. So really quickly, I'm just going to go through a few things in the next few minutes, and then we can get to some questions. So I want to cover some of the lawsuits. I want to talk about trusts briefly, dissolved entities, and then some other updates. So there were a few lawsuits filed starting in March. I remember I was on vacation the week this was filed, and somebody said, "Oh, the CTA is, CTA is gone forever because of this decision." No, it's not. It was just the court ruled the CTA unconstitutional in Alabama. However, it only applied to the plaintiffs in that case. So if you weren't a plaintiff in that case, the act still applies to you, and that decision is being appealed. So for the rest of us, it still applies. And FinCEN made that clear and said you still need to make your filing. So I think this is the latest procedural posture of this. So it looks like we have oral arguments coming up in a few days. So I'm sure that will be fascinating discussion. And there are some other lawsuits that have been filed as well, all along similar lines. Nothing has killed the CTA yet, and might go up to the Supreme Court someday, but that deadline's coming down the pike, and we won't have a decision before then. So chances are you're going to still need to comply with this, and you better just take care of it and take your medicine and make the filing before the deadline happens, especially if you're a newly formed entity, because that deadline is quickly approaching. Again, so for trusts, I covered this, tried to work this in earlier. The takeaway there is if you're a trust and your common law trust, you don't need to make a filing yourself. But if the trust owns 25% or more of a reporting company, one of those trustee, beneficiary, grantor, settlers will need to report themselves as a beneficial owner on the filing for that entity. It really comes down to a few things. If it's a revocable trust, then the settlor will be reported. If there's only one beneficiary who could ever received trust principal, then the beneficiary reported. That would kind of be like a trust fund set up for a kid or something. If you're not one of those two situations, again, revocable trust or trust fund, sole permissible beneficiary, then it's going to be the trustee who's reported as the beneficial owner. So happy to go through that analysis for you. It's you have to review each trust agreement, so that's why it's a little bit more complex and to make those determinations. And then one of my least favorite updates that have come out in the past year has been this dissolved entity. I'm not going to put this politely, nonsense, but essentially they come out with the conclusion that even if your entity was dissolved on January 2nd or any other time this year, if your entity was in existence as of January 1st and you were a reporting company on that day, you need to make a filing. So even if Dan filed your dissolution papers on January 31st or September 16th or whenever, you need to make a filing on or before your filing deadline. So I don't get it. The entity is not in existence anymore, but I guess potentially they could have been engaged in some nefarious act since January 1st, even though they're being dissolved. So FinCEN wants you to make a filing. So not a fan of that one. But you still got to make the filing. That's what the act says. And it's been issued pursuant to these frequently asked questions, which have really been helpful. And I don't want to give FinCEN too hard a time. I think they had a difficult statute to interpret. But because of a recent Supreme Court case that was overturned called Chevron, there's going to be a lot less deference paid to federal rulemakers and regulations. So courts used to have to kind of defer when a statute was ambiguous to rulemakers. That was called Chevron. That was wiped out earlier this year by the Supreme Court. So that deference is gone. It's going to have big impacts on all sorts of federal laws. And nothing's been filed yet, but stay tuned on that, because I think there's probably going to be some challenges from an administrative law perspective about FinCEN's authority to issue guidance on things like dissolved entities or other things, and whether they had authority to do that under the statute. So, whether that ambiguity should be cleared up by them. And obviously, there's going to be some judges who aren't too keen of the CTA, so could make for some interesting cases coming up. This is the portion of the presentation where I want to get to your questions. So Travis, I'm gonna see if I can do this here.
Yeah, if you go to the chat, Dan, there was a few posted in the chat, not in the Q&A section. I think there's 4 or 5 that were listed in there.
Okay.
If you want to just go through as many of those, we have about 5 minutes, folks, so we'll do as many as we can, and any that we can't answer, we'll follow up with you separately.
Sounds good. So I'm gonna read these from top to bottom, and thanks for participating in the webinar and giving me these questions. So the first one says, I'm the sole owner and hold all the stock for my company, which is a Type S corporation. Am I required to file? Yeah, it sounds like you potentially could be. If you've elected S corp status, that means you're an entity created by a state filing, and you filed an S election with the IRS. And you own all the, unless you're an exempt large operating company, so you have that 21 employees, 5 million revenue test, U.S. operations, then you're probably going to have to make the filing, and you'll report yourself as the beneficial owner. I think I might have answered this next one actually during the presentation. If mom reduces her shares to 20% by passing 20% to a child, does child have to file BO since it's less than 25%? What update to the CTA file? Please re-elaborate. Yeah, so in your scenario, mom would have been a 40% owner, it sounds like, and she gave 20% to her kid. Then they'd both be 20% owners. If I'm reading you right, they'd both be under the 25% threshold. Kid does not need to make a update or name itself as a beneficial owner because they're only 20%. But unless they're under that substantial control problem, but mom has gone from being a beneficial owner to no longer being a beneficial owner. Company needs to update to remove mom as a beneficial owner. Any need to amend operating agreements currently in effect? There's no requirement under the act. I think it's a best practice, and we're putting it in all our new operating agreements going forward. You don't need to. I think it would insulate the company, its officers, from potentially being liable. Then they could look to the member to indemnify them, which we do have indemnification language in there, and get their back against any actions that are filed against the company if you have that operating agreement language in place. So if you'd like to have me dust off your operating agreement and put that in there, let me know. I'd be happy to take a look at that for you. But there's no requirement under the act. That was just kind of a best practice we put in there. Had an LLC partnership I sold years ago, sold assets, received monthly payments. LLC has done no business since the effective date of the sale. It sounds like that's not your. Oh, okay. So it's your LLC. You sold the assets. It's just kind of been sitting dormant. Sounds like that might be an inactive entity if it hasn't been doing anything. Although you receive monthly payments, so you are getting money. So yeah, I think you're probably gonna have to file there unless you're under that inactive entity threshold, which I think is $1,000. But you're going to want to look at that exemption or call me and we can have a discussion about it. Unless you're in an active entity and you meet all 6 of those criteria, you're going to have to make a filing for that LLC. And you might, yeah, and I understand why you're keeping it around because you're still receiving payments. In the past, I've seen rights to payment assigned to owners in that situation, and then entities being dissolved. So that's something you could do too to get rid of the LLC and just have yourself receiving payments. Does the person doing the online filing need to get a FinCEN for themselves if they are not an owner or an officer? The person doing the filing, the FinCEN, the CTA filing does not need to, it's more or less just a task that's being done on behalf of the company. They're not reporting anything about themselves unless they're a beneficial owner or company applicant. And so they would not need to in that scenario. If I have a FinCEN ID and change my address, do I need to make any changes to the entity reporting? I think you would need to update your FinCEN ID information. I think they ask you to do that when you, when you need to update your FinCEN ID filing. I don't think the filing itself would need to change because you just reported a number, which isn't changing. But if information about you changes in there, I think FinCEN wants to know about that. So that's your answer there. Did I cover all of them, Travis?
I think you did. You got through them, and you had about 5 minutes to do it. You're very prompt. Dan. Thank
Yeah,
you for that.
no, I
So.
don't want to hold anybody past their lunch hour.
No, that was perfect.
So,
That was perfect. And the one question that we do get at Trout, just to cover this in the presentation, is will Trout prepare these forms? Unfortunately, we will not be preparing these, hence why we have Dan here today. It's part of our insurance carrier, and we're just listening to them under, unauthorized practice of law. We don't practice law. We stick to our lane in accounting. But like I said, if you have any questions, Dan would be a great resource. Your attorney is your best line of defense to getting these filed, and January 1st will be here before we know it. So make sure that you guys are proactive with that. So
yeah,
with that, on behalf of Trout, I want to sincerely thank Dan. Thank you very much for your time and your presentation. You did a wonderful job as always. Thank you to all of our participants for joining the call today. If you have any other questions you think of, feel free to email us, email Dan, and we can make sure we get all your questions answered. So with that, everyone have a great day. Take care.
Thanks, Travis.